thank you again for joining, for everybody who's on the call today, for joining our What Are the Experts Saying webinar. Today we are going to be talking about Reg A Plus. And actually, you see the title at the bottom. It matches a strategic perspective from our expert today. Reg A Plus Flies in Blue Sky. It was written by Jay Fishman. So we'll be talking about that today. And before we actually begin the webinar, let me begin with a couple of kind of housekeeping type things. First of all, introducing myself. My name is Dan Sotillo. I'm a legal training consultant with Wolters Kluwer, and my colleague and co-moderator today is Jenna Ellis. Jenna, you're there as well? Hello. And Jenna will also be watching the chat messages today. So if you have any questions during the session or any issues, please don't hesitate to use the chat feature at the top of WebEx. Since all the lines may be muted, please take advantage of the chat feature and choose Jenna Ellis and send her any questions, and we'll be answering any questions near the end of the session. And with that said, let me introduce the most important person for on our side on the call, Jay Fishman. Jay, many of you know Jay. He's a senior writer analyst in the Securities Group here at Wolters Kluwer. And Jay, you've been with the company a long time.
Yeah, about 25 years.
25 years, yeah. So many people really know Jay. Jay is a regular contributor to our industry standard publication for Blue Sky Law, the Blue Sky Law Reporter, the Securities Regulation Daily, Jim Hamilton's World of Securities blog, many of our publications and information. Jay's been a contributor, et cetera. So, and Jay also developed the Blue Sky Smart Charts. They're an innovative workflow tool. I think many of you know our Smart Charts, and Jay developed this. This is almost one of the first and most precedential and wildly popular smart charts. So Jay was responsible for that. So, and so Jay's truly our expert on Blue Sky. So thank you for joining today, Jay.
Oh, thank you, Dan, Jenna.
All right. Well, I guess we'll start by with an overview of what we want to cover today, and then get right into it. Because I know you wanted to start, Jay, with a little bit of a very brief history of Reg A, and then really moving on to what we're here to talk about today, that new Reg A Plus. That was where the final rules just came out a couple months ago. That new Reg A Plus, we're going to move on to then talk about Tier 1 versus Tier 2. That Reg A Plus defines those two tiers for different offerings within the A Plus. And then I think one of the most interesting parts is the Blue Sky impact. That's what that's leading up to, because, Jay, you've said before, a lot of people think of this as just a federal, when it first came out in June, as a federal issue, but there really are state implications here.
Yes, that's true. Exactly, and it comes through the NISMIA section 18B3 of the Securities Act of 1933, so it's a long time ago. But it does, that's how this state piece comes through the Reg A Plus rules.
Okay. All right, so we'll go up to that, but I know you wanted to start, I think I sometimes almost incorrectly say that this all really started with the Jobs Act, Section 401, but it really started before then, the history of Reg A.
Yeah, I mean, Reg A has been around for quite a while with the SEC, but it capped out at $5 million. And in more recent times, $5 million in the securities industry is really not a lot for making an offering in multiple states and across the U.S. And so through the Jobs Act, Congress charged the SEC with coming up with a more viable rule to entice securities issuers to make offerings to help them raise capital, raise jobs, and so they came up with the Reg A Plus rules, which were adopted just recently, a few months ago, on June 19th of this year. And basically there are two tiers, one that caps out at $20 million in a 12-month period, and the other one that caps out, allows you to make an offering up to $50 million in a 12-month period.
And we're showing that slide that kind of gives the overview. I guess that, as you mentioned, it's a great place to start. The two tiers really are defined initially by that offering amount, but you can see in the bullets here there's kind of a different focus for each one, or that was the intent.
Right, yeah. The first Reg A really just capped out at $5 million for every type of an issuer, but the SEC thought that by creating two different tiers, they could basically allow two different types of companies to get involved. The $20 million, which is the Tier 1, the lower amount, is really for more local issuers that are going to just make a securities offering in a couple of states, whereas the $50 million offering cap is for larger issuers, larger companies that are more global in nature and want to make an offering in many states. They're usually the more well-known companies.
Okay. So, and as we're talking about, the two different tiers, I guess a good place to start is, some of these areas like who can invest. This is the investment limitations are different for each tier.
That's right. In a Tier 1 offering, maybe because the states are allowed to qualify that particular offering as well as the SEC, that offering has no limits. I mean, anybody can invest in it. They can invest, any investor can put in however much money they want to. Whereas Tier 2, because it's a higher amount, there's more chance of fraud and risk. It's really limited pretty much to accredited investors and exchange-listed securities. If you are, however, not an accredited investor, if you are particularly a natural-born, non-accredited investor, you're pretty much limited to like 10% of the greater of your annual income or net worth, which is determined by Reg D Rule 501's definition of accredited investor. If you're the other type of non-accredited investor, which is a non-natural-born accredited investor, then you're limited to no more than 10% of the greater of your revenue or net assets as of the most recent fiscal year. So there are some investment limitations between the two.
Between the two, okay, and then as far as differences between the two, I think I have it up on the slide here. A real key difference you've said that the SEC really highlights is the difference between these two is that ongoing reporting requirement. Is that correct?
Right. First of all, let's just say that if you are going to make a Tier 1 or a Tier 2 offering, you're going to still file the old the Form 1A, which was used in the original Reg A. Form 1A actually has, and if we go to the next slide, it actually, Dan, if you want to explain this, where this is coming from.
Oh, yeah. We're showing a screenshot. Yeah, I think so. This is a screenshot of the instructions for Form 1A, and we're taking this from our RB Source Filings platform, which is, for those who aren't familiar, that one's it's basically the red box online. And so, yeah, we're looking at the instructions, I think, here for Form 1A, and I'll open up the index, Jay, because I think here's where you wanted to talk about the three parts.
Right. Form 1A has three parts, and basically, if you're a Tier 1 or a Tier 2 issuer, many of the kinds of information you're going to provide in parts 1 to 3 of the form are going to be the same, but there are some differences. If you're a Tier 1 issuer, you're going to file 1A, and when you exit or terminate the offering or complete it, you're going to file Form 1Z. Now, for the Tier 2 issuers, this big piece that the SEC emphasizes as being one of the major differences between Tier 1 and Tier 2 is the ongoing reporting requirement. So where Tier 2 varies from Tier 1 is, in addition to filing the 1A that a Tier 1 issuer would file, the Tier 2 issuer must also file a 1Z, which is the annual report, a 1SA, which is a semi-annual report, and a 1U, which is the current report. Now there is a way, and this is in the Reg A rules, amended rules, that the Tier 2 issuer can qualify out of having to comply with the ongoing reporting requirement. And if the Tier 2 issuer meets those requirements, the Tier 2 issuer does not have to file the 1Z or the 1SA. It doesn't have to file the 1K or the 1SA or the 1U, but instead, like the Tier 1 issuer, can file a 1Z to exit out of the offering when it completes or terminates. Otherwise, there is an ongoing reporting requirement for a Tier 2 issuer that doesn't qualify to avoid that requirement.
Okay. And then I guess one other difference that you noted is, well, actually a couple more, but being financial statements as far as whether they're audited or not audited requirement.
Right. For Yes, for Tier 1, a Tier 1 issuer does not have to file audited balance sheets and other financial statements. The Tier 2 issuer, on the other hand, has to provide audited balance sheets and other audited financial statements as of the two most recently completed fiscal years. Or if it's a startup company or a development stage company which hasn't been in business for about a year, then basically from the time that issuer first existed. And another difference is that for the Tier 1 issuer completing the financial requirements or the financial statements, you would follow Form 1A, Part F/S. But if you're the Tier 2 issuer, you're going to make your financial statements in compliance with Federal Regulation SX, Article 8.
Okay. And then one other difference, I guess, would be also the executive compensation reporting. It's also a little different.
which is on Part 2 of Form 1A. And if you're a Tier 1 issuer, when you get to this part of filling out the form, you're going to need to disclose the executive compensation you're going to provide the group level data for the 3 highest paid executives, so collectively. But if you're a Tier 2 issuer, you're going to provide individual level data for the individual 3 highest paid executives or directors, as well as for the directors as a collective group. So there's an added piece to the Tier 2 executive compensation part of the filing.
Will they have to report on those individuals' actual compensation?
Yep. Okay. Exactly.
Well, I think the last slide we had before we kind of talked about the blue sky impact, let me switch to the next slide here, is the related party transactions. I guess there's also disclosure differences here.
Right. Yeah. On the form, you would have to disclose the transactions with related persons or promoters and certain control persons. But for Tier 1, you would make these you would disclose the transactions that exceed $50,000 in the prior 2 years. For a Tier 2, you would disclose these transactions for people for transactions that exceed the lesser of $120,000 or 1% of the average total assets at the year end for the last 2 complete fiscal years. Otherwise, other than those for, the financial statements, the ongoing reporting, the executive compensation, and the related transactions, everything else in the parts 1 through 3 of the filing of Form 1A is going to pretty much be the same whether you're a Tier 1 or a Tier 2 issuer. I just wanted to emphasize that.
Okay, great. That's an important point, too. All right, so then as we transition over then to the blue sky impact, this is the part where we said at the beginning a lot of folks thought of this as a federal issue only, and hadn't thought of the state, and it is so new, that we're following that now. But I guess one of the big differences here, one of the key factors that makes this a state issue is this definition of qualified purchaser. Is that correct?
Yes, and we have to go back to the NISME Act. I know all of you are familiar with it from 1996, where Congress set up Section 18B3 of the Act, basically to create that preemption exemption for issuers, for qualified purchasers. But the caveat was that the SEC was required to define a qualified purchaser for that particular exemption to go forward, and they never did. And so California, for example, was one state that did have like a notice filing and fee requirement for 18B3, and they suspended it at some point in the 90s. Because the SEC did not define a qualified purchaser. So all of a sudden, what's happened is in the Reg A rules, the SEC has finally defined a qualified purchaser, and it's defined as a Tier 2 issuer making a Regulation A offering. So now you do have a qualified purchaser definition in Section 18B3, which allows the states to have a notice filing and fee. Because remember, for Tier 1, the states and the SEC can qualify and regulate that offering. But for Tier 2, only the SEC can regulate and qualify it. The states can't. But just like with Rule 506, where under NISME, the SEC and the Congress preserve to the states the right to require a notice filing and fee, the same thing is happening here in 18B3. The states can't regulate Tier 2, but they can certainly collect some money from the offering if the offering is going to be made in their particular state by requiring a notice filing and a fee for that offering.
And so even though this really just came out in June, the final rule at least came out in June, I guess we have already 3 states that we've been following that have either proposed, that we're showing on the screen now, either proposed or adopted in one way or another a structure of that notice filing fee?
Yes. Okay. The rules, as I said, were adopted June 19th. And right after that, I think it might have been the week right after that, Washington State was the state to propose a rule, the first state to propose a rule to provide a notice filing for Regulation A Tier 2 issuers under 18B3. Followed by North Dakota, which more quickly adopted a notice filing requirement in July as a policy statement, so they wouldn't have to go through the rulemaking process. And similarly, New Mexico did the same thing a month later, actually just 6 days ago on August 20th, through an administrative order. So,
okay. Well, and that brings us to what we've been following, because I think, well, I mean, I know you've added a category already to the Blue Sky Smart Charts and for A+ because of these, very recent developments. And I guess I'll start by putting on the screen here for those folks who may not be familiar with our Blue Sky Navigator. It's a new product that brings together the trusted content people know from Blue Sky, and it puts it together on the new Navigator. It's one of the ways that you can access the charts. Actually, a really simple and easy way to access the topics. But I wanted to show this just as a way to introduce that content, because when you go to this Go All Blue Sky Topics on this nice homepage, it takes you to a list of the topics, and here's where I wanted to highlight. Here's where, Jay, I guess people would choose Regulation A+ to see these developments on the Blue Sky Smart Chart.
Exactly.
Okay.
And then beyond that, go ahead. There's the first state, the one I mentioned, Washington, which proposed notice filing, the first state to do it. And Washington may be the typical pattern of other states that follow, because they provide a notice filing for making an initial offering as well as for renewing the offering. And then if you have to file an amendment, there's a provision for doing that, which requires filing. In Washington, it'll be Washington will have its own Reg A Tier 2 offering notice filing form and a fee, and then the renewal will occur, and then there'll be a filing for an amendment, which also involves a fee.
And we saw this, if I remember right, Washington was also in the forefront on crowdfunding and these types of state adoption.
Yes, so Washington... Yeah, in recent years, Washington seems to be the state that starts the trends. For example, Washington was the first state to incorporate the bad actor provisions from Rule 506 when Rule 506 was amended a couple of years ago. And then Washington has a crowdfunding act provision as well as crowdfunding rules. And now Washington is the first state to actually propose a rule following the Regulation A amendments by the SEC. Just a couple of months ago.
But as you pointed out, this one's a proposed rule because they're going through so they're in the comment period now, right? So that one's not,
yes,
that hasn't been finalized.
Exactly.
Okay. But in contrast, as you said, I guess, let me move to the next slide here. North Dakota actually already, I don't know if the right word is adopted, North Dakota already moved forward. Yeah.
Right. North Dakota, that's the first piece in that chart is the enabling statute, which basically allows the commissioner to require a notice filing for 18b3. The second one is actually the actual policy statement that just was adopted July 15th of this year, where they set forth, just like with Washington, a requirement for filing an initial notice, a renewal, and an amendment.
And they didn't go through the rulemaking process. They
avoided it by going through a policy statement situation that allows it to be like up there, right away and effective and ready to be used.
And then I just wanted to point out in this third column, in the comments column of this, again, we're looking at the Blue Sky Smart Chart. You've populated throughout that chart some links to a couple of documents that you, I know you believe are very valuable.
The first link for all the states is the link to the Regulation A amendments that were adopted in June. It's a 500-page document. It pretty much sets forth the federal requirements, what's different between filing 1A, whether you're doing a Tier 1 or Tier 2, and what you fill out in Parts 1 through 3, and a whole bunch of other things. A little bit about the state piece, but not too much detail. That was kind of left for the states to work out themselves. And then the other linkable document is an SEC investor bulletin. It's really for investors. It basically tells them, what they need to watch out for if they're going to invest in a Tier 1 or Tier 2 offering. But if you're an issuer or the legal counsel for an issuer and you're not really familiar with the amendments, this little bulletin is a great place to start because it points out some of the high points very quickly for what the differences are between Tier 1 and Tier 2. So that's in there for all the states, even the ones that haven't adopted a notice filing requirement yet.
Okay, and we can even see that here on New Mexico. That example, they're everywhere. But New Mexico also adopted. They were the third one just 6 days ago.
Right.
Okay.
New Mexico is the most recent, and as far as I know, the only other state to have so far adopted Tier Tier 2 notice filing requirement. Theirs is very simple. They don't go into details about renewals or amendments. It's just for the initial filing, you file a New Mexico form, and it looks like all the states are going to have their own individual form you file to make the notice, and then you pay the fee. Now, the $350 fee is actually the same fee that you would file for a lot of the exemptions in New Mexico, including the Rule 506 notice filing. So there's a similarity there between 18B3, which is this Tier 2 offering, and 18B4D, which is Rule 506.
Rule 506. Okay. Well, so I guess I don't know if there's anything else you want to add on the states, or we'll move over.
No, I mean, just the fact that with states, usually state provisions that come following a major federal adoption, like Reg A or Reg D, usually have a domino effect. So that I would say that 6 months down the line, we may see a whole bunch of states that have a notice filing, because again, they can't regulate the merits of the Tier 2 offering, but they can certainly collect a fee for issuers that make that offering in their states, and they can also are preserved with the right to pursue fraud or any unscrupulousness with the transactions that take place on the back end. But yeah, I think we're going to see, just like we did with crowdfunding, which has a lot of states already having even gone around the SEC, which hasn't even adopted the crowdfunding rule yet. You've got the states, many of them who have crowdfunding provisions already set up. And in fact, we have seen some actual companies taking advantage of those exemptions, like in Indiana, there's a farm purveyor. In Wisconsin, there's a brewery. D.C. has had an actual crowdfunding offering taking place. Because Reg A is so new, we don't really have any examples yet of issuers that are taking advantage of it. But no doubt some will, I'm thinking.
Yeah, and that's where, and that's why, again, we wanted to show, like, for example, in the Blue Sky Smart Chart, where you would see those developments, because it's something that it sounds like we're following, or we will follow to see what happens.
Right. Yeah. So basically, it all comes down to the fact that through the Jobs Act and before that, the Dodd-Frank Act, Congress is trying to come up with ways to remove the outdated rules that have restricted companies from raising capital and providing jobs in a difficult time, and being able to compete against international companies. And so this is yet another way, along with 506, along with crowdfunding, that the SEC has come up with a way to give companies another option for making an offering in their states by providing the two tiers for different offering caps, separating it out by one for local issuers and one for more national issuers. But only time will tell whether how many and who of the companies and issuers take advantage of the new rule and the new notice filings.
Great. All right. Well, I know that was the majority of what you wanted to cover, and I guess this is a good place to stop and see, Jenna, if we had any questions that came in while we were talking.
Yeah, let me double check the chat here. I answered some questions during the webinar, and yes, actually we do have one. It is, okay, what does Regulation A+ mean for a smaller startup or smaller IPO?
Actually, even compared to Reg D Rule 506 and the crowdfunding, what makes Reg A Plus really a great start for startups and development stage companies that haven't been in business a long time is the fact that even though they may be public companies, their disclosure requirements are so much less than what's typically required for public companies. And so Reg A Plus and the two tiers and the two offering caps actually turns out to be a really great place for startups to get on board making an offering and helping them raise capital. Of course, on the other side of the coin are the investors. Investors are cautioned by the SEC that if they do invest in a startup, they really need to know about the risks, because a startup may not end up having a market, and so then the investors could potentially lose a lot of money from the investment. But for the startup company itself, it actually is a really great place to start. if you're not sure of how to make it, like which type of rule or reg would be the right way to go, the Reg A Plus is as good as any for making a start.
Okay.
All right.
And actually, I just had another one, and I think this is a good one just for a kind of a clarification or a summary. So it says, since there's no blue sky preemption for Tier 1 offerings, what is the procedure for blue sky compliance in this tier, Tier 1?
Well, this one, this is one that's going to allow, full state regulation of the merits of the offering. I don't think that anything has really come through the states on this yet. Because it is so new. I think the states are right now focusing on, or seeming to focus, from what we've seen with Washington and North Dakota and New Mexico, on getting Tier 1, Tier 2 notice requirements in place. So I really don't know at this point. It's a great question, and I was wondering about it myself. Like what, to make a Tier 1 offering, what are the states requiring? But I don't think that anything has been put forth yet specifically about that, because it is, like I said, it's very new with the federal rules just having been adopted a couple of months ago. But I would, if anybody knows of anything, that would be great. Is that something we'll
watch then, Jay?
It would be a great thing to watch, because it may turn out that Tier 1 is going to be a very popular type of offering that the states are going to regulate, and that companies are going to want to make offerings in connection with. But as of right now, the focus seems to be on getting Tier 2 notice filing requirements in place, and maybe because the states feel they want to handle that first because they can't regulate the merits of that offering, so they want to have something in place to be able to, put their stamp on that particular type of offering.
Let's be something to follow and watch.
Exactly. Actually, Tier 2 and Tier 1 should be something to watch to see how they compare with crowdfunding and how they compare up against Rule 506, if they take away some of the Rule 506 popularity, or whether 506 remains the most popular, type of offering, because it has no limit on the offering amount. But like I said, this is all so new. Even crowdfunding is rather new, so I think we're going to have to wait about 6 months to a year to see if there's any predictable pattern that's coming through all of this.
Definitely, thank you. And Dan, thanks for putting up this slide. If there are any other questions, my email address is right up there on the screen. So feel free to email me. And then, of course, any requests for training, there's the email address, legaltraining@wolterskluwer.com. Thank you so much for attending. We appreciate your being with us.
All right. Thanks, everybody.
Okay. Thank you, everybody.